rights based on their choices, character, and abilities since 2007. Thank you for coming to speak to us, Mr. Thompson.
Thank you for having me. Thank you to to CFER. What a great organization. What an inspiring place to be right now, to see all of you individuals here today to fight for equal rights. A huge thank you to Ed. I know you've heard a lot of thank yous today. I started my legal career in 2007. I was working on education cases from the get-go. And the day when SFFA came down, I had driven to work really early because I wanted to be there because I'm in California, so I had to get to work by 7 to be there when the Supreme Court announced the opinion. I was hopeful, but not without my skepticism. I'd been through Fisher, and of course, that's the day that Sacramento had a huge traffic jam. So I didn't get to work on time, but my colleagues started calling me and texting me, we won, we won. Everybody at PLF was overjoyed. I'm going to end my speech with a little message that I sent to them, but huge thank you for me. All Americans, thank you. A great day for equality, and I couldn't be more proud to know you and to at least have a small part to play in that fight. I was a little bit surprised with the introduction. That's not exactly what my speech is going to be on. I'm going to talk a little bit about the ubiquity of racial classifications in American society today. The victory that was SFFA is a beginning. The beginning of a new civil rights moment. And with foot soldiers here, with foot soldiers across the country, we can end racial classifications in government once and for all. And that is what my speech is hopefully going to be, inspiring at the end, if not very depressing as I go through how ubiquitous racial preferences are. But if we take a bit of a historical perspective, Thurgood Marshall in 1935 won a case that nobody's ever heard of called Murray versus Pearson. It dealt with racial classifications, whether a Black applicant to a law school could get in at the University of Maryland. He won that case in 1935. Nobody knew it, wasn't appealed to the Supreme Court. It was a Maryland Supreme Court decision. And that was sort of the spark that ignited a civil rights moment then. It didn't culminate in Brown versus Board of Education, but Brown versus Board of Education I see as our SFFA. After Brown, you had a lot of enforcement actions to enshrine the right to equal treatment before the law, culminating in the 1964 Civil Rights Act, which ended discrimination across America in so many different aspects. That is my call to action to you today, is that when I list the litany of racial classifications that are throughout American society today, let's use SSFA as our moment to spark a new civil rights for America. We have a court that is receptive to us. We have 10 years. Now is the time to act, and now is the time to bring cases, to be active in your school boards, to be whatever your expertise is now, use it to make this a reality. So with that, education. I want to talk a little bit about SFFA. There was talk about the essays and how that may be an opening for backdoor racial preferences. I don't really see it that way. I think that's a very poor reading of the Chief Justice's opinion. It would be ludicrous to say to college students that they can't write about their own personal experiences. That would be a violation of the First Amendment if a college would say that. Of course, they could write about whatever they want, but the chief was very clear that each individual has to be judged based on their individual characteristics. So if at some point the universities start using these essays and everybody that mentions race all of a sudden starts getting in, and everybody that starts mentioning a different race doesn't get in, well, then you're not judging them based on their individual characteristics. Then it's a proxy for race, and then it can be challenged. But that doesn't mean that individuals aren't allowed to talk about their own personal experiences. Of course, they ought to be able to, but we have to be active and recognize that colleges and high schools across the country are going to try to find ways to use proxies. Maybe it's essays. I don't think it will be essays, but they will use other proxies frankly, we already know that they will do that because we live in California. And despite Proposition 209, the great victory that it was, the great defense of Proposition 209 3 years ago, UCLA and Berkeley are, of course, using preferences. They are using proxies to approximate a racial balance goal that they have. We know this. They've been doing it probably for 10, 15 years. We at Pacific Legal Foundation have brought challenges to K-12 admissions policies. K-12 notoriously, or positively, I should say, has not been allowed to explicitly use race since a 2007 decision by the Supreme Court. And so selective high schools have very recently tried to figure out ways to get around this prohibition on race. It started from our experience with New York specialized schools. We represent the Chinese American Alliance for Greater New York, CAGNY, as well as middle schools in New York that were challenging Mayor de Blasio's and Chancellor Carranza's decision to racially balance these elite specialized schools. But they knew they couldn't do it by race, so they used different racial proxies. We've challenged similar laws in Boston and in Montgomery County, Maryland, and in famously, or what I'm going to talk about now, Fairfax County, Virginia, with our Thomas Jefferson case. This is the case that has progressed the farthest in the courts up to today. Our New York case is at the Second Circuit, our Boston case is at the First Circuit, our Montgomery County case is at the Fourth Circuit, but TJ is on the brink of the Supreme Court. The petition will be filed next week, and we will ask the court to review what happened in Fairfax County. So what did happen in Fairfax County? In 2020, about a week after George Floyd was murdered and riots were consuming the country, Fairfax County released its admissions data, TJ released its admissions data. I should say TJ is routinely ranked the #1 public high school in America. You can take classes there that you would only see in elite universities, differential calculus. These kids are taking, they're brilliant, brilliant kids. But the racial composition of the school in 2000, a week after the George Floyd murder, was 73% Asian American. That didn't sit well with the school board members in Fairfax County. So they completely overhauled their admissions criteria, explicitly saying over and over and again that we need to balance it. It needs to mirror the demographics of Northern Virginia, and we're not even close. So what did they do? Well, they found a couple of really good proxies. They see in Fairfax County, Virginia, there are 2 very select middle schools where all the kids that end up going to TJ go to these middle schools. So they said, if we can balance out the class by middle school, then we will, sort of like in the voting cases where you pack all of the Democrats into one area, you'll pack all of the Asian kids into 2 middle schools, and then we'll have a middle school quota to reduce the Asian American population. Then on top of that, we'll graft preferences for reduced lunch, social economic status, and other factors. And what happened? The very next year, Asian enrollment at TJ plummeted by 26%. Exactly the goal that they set out to do, and we challenged that as a violation of the Equal Protection Clause. Now, this case is going before we're hopeful that the Supreme Court takes this case and issues it, because the promise of SFFA is that when the Constitution prohibits discrimination, it prohibits all of it. We can't countenance school districts like New York City, Fairfax County, to go around the promise of equal protection through racial proxies. They are upfront about what they're doing, and the Fourth Circuit said, as long as they're out to help Black and Hispanic students, that doesn't mean they're out to hurt Asian students. Of course, as is also said in SFFA, admissions are zero-sum. A benefit to some is a detriment to the others. And if this, and we're very hopeful that this case will lay the groundwork for when UCLA, when Berkeley, when Harvard, when, fortunately not UNC, because they just came out and said that they were not ever going to institute racial preferences in hiring either. But when these universities try to circumvent the law, we will have a roadmap from the Supreme Court that says, no, you can't do that, and this is how you challenge it. So that is one aspect of education that is important that we fight, the proxies that are going to come and are going to try to racially balance classes. But there are a lot of other education preferences that are going on. Grants, Gail talked briefly about grants to Hispanic institutions or grants to different medical colleges for doing particular research for disadvantaged communities. These need to be challenged. They are all over the place. One of my colleagues back here, Andrew Quino, has filed 3 challenges to COVID grants. Andrew, you want to wave? What happens when Andrew challenges these? Well, they are obviously unconstitutional. What's happening here is the government is saying, during the pandemic, everybody suffered, but we want to give extra help to those Black and Hispanic businesses that suffered more. So Andrew has challenged a number of these policies. And as soon as he files suit, the government says, oh, we're just kidding about that. We're going to retract that. So his lawsuits in Cook County, Chicago, in Colorado, and his latest one in Boston or in Massachusetts are all likely to go away because the government recognizes that what they're doing is blatantly unconstitutional. That just underscores how we need foot soldiers to be doing this. And we need people to be filing lawsuits challenging these obviously unconstitutional race-based grants. They're happening in education. They're happening outside of education. I did want to say one more thing about education. In addition to the race proxies, there are still express racial classifications in education. And Gail mentioned earlier how she couldn't imagine a quota that said 25% white kids are entitled to this school would ever be sustained. Well, I litigated that case. And in fact, in Hartford, Connecticut, there was a quota that said that every magnet school in Hartford, Connecticut, a notoriously very segregated city, suburbs white, city Black, every magnet school within the city had to be 25% white. Like, what? How could that possibly be the case? And we represented Black and Hispanic families who were denied entry into these schools because they were Black and Hispanic. And who supported this policy? Who was on the other side? The NAACP was on the other side. This policy arose from a 1996 decision in the state of Connecticut that held that de facto segregation in the schools of Connecticut had to be remedied through race-conscious means. So what does that mean? Well, because it's hard to get the white kids from the suburbs to come into the inner city schools, we're going to force them to by creating a quota. And if you can't fill that quota, then the seats have to stay empty. Didn't really work, so the seats stayed empty. So to every student that would fail the quota over that 25% was not allowed to be enrolled. So you had the best schools in Hartford, really the best. I mean, I walked into one of these schools and had a vivarium. Who knows what a vivarium is? Anybody? It's a butterfly exhibit. And so like butterflies were like flying at me as I walked into the school. It's a beautiful, beautiful school in the inner city, awful part of Hartford. My clients lived basically across the street. We're not allowed to go in there because it had to remain at 50% capacity, because if they enrolled another Black kid, it would upset the 25% white quota. So racial quotas and racial preferences are still in K-12 education expressly, and that's through desegregation orders that are ages and ages and old, zombie desegregation orders. So we'll have minority to majority transfer requirements. I represented a Black kid in St. Louis who was unable to transfer to a charter school in the city of St. Louis because the minority to majority transfer only went in one direction. And if you wanted, only the white kids were allowed to go into the city of St. Louis. That made sense in 1984 when there were no good schools in the city of St. Louis and nobody from the suburbs wanted to transfer there. But in 2015, some of the best charter schools in the area were in the city of St. Louis. And my client was not allowed to go there because he was Black. So this isn't a Black-white issue. It's an issue of equality and treating everybody as individuals. And there are ubiquitous race-based preferences throughout education. But it's not just education. I mentioned funding, medicine. We've heard a little bit about medicine. One of the cases that we brought to the Supreme Court this year, now PLF had 3 Supreme Court cases that were argued this year, all 3 wins. One of them that we petitioned that wasn't granted there was a descent from denial on the last day of the term. So this is after SFFA and everybody forgot about the Supreme Court. We had challenged a policy of the city of New York that dished out Paxlovid, which is the COVID not the vaccine, but the medicine that helps you overcome COVID symptoms, was being dished out to individuals on the basis of race. So if you were Black, you got the medicine. If you were white, you didn't get the medicine. And unfortunately, by the time that case made its way through the Supreme Court 2-3 years, the pandemic was over, right? And so the Supreme Court said, pandemic's over, we're not going to take this case. But in a dissent, or in a statement respecting the denial, Justice Alito said, but in the event that the government resorts to using rationing race medical treatments on the basis of race, prompt review is required by this court. So the court is ready to hear these cases, and the medical boards out there are unfortunately not stopping. They are believing that medicine is the next frontier for race preferences. We've seen it in education, we've seen it in contracting. One case that we filed a month ago dealt with CME requirements in California. CMEs are continuing medical education requirements. Lawyers will know them as CLEs, continuing legal education requirements, but doctors have the same requirement. Every 2 years, they have to take 50 credits of CMEs. California, however, has a law that says every CME course must contain an implicit bias discussion. Not like lawyers have an implicit bias requirement too. That's, you take one course, it could be saying implicit bias is bunk, it can be whatever. No, doctors have to take an implicit bias every course that they take. So imagine course on brain surgery, course on how to do an appendectomy. Now that's an hour-long course. The last 5 minutes have to be on implicit bias and how you should be thinking about race when you're performing brain surgery. Scary stuff. It's injecting race into the doctor-client relationship, what should be sacrosanct. It's telling doctors how they ought to think about their patients, that the thing that matters is the race of their patients. Anyway, medicine is another area where we have to be hypervigilant. I mean, this is going to kill people. I was happy to hear that Ed is going to be working on contracting. We are working on contracting as well. We have a case challenging Section 8A of the SBA contractor in Virginia. Contracting is the next white whale, I think, at the Supreme Court. It's been 30 years since the Supreme Court heard Adirond, which was a great decision at the time. Adirond and Croson, 6 years apart, held that racial preferences in government contracts are unconstitutional unless they are designed to remedy past discrimination through maybe a disparity study. Kind of a throwaway line by Justice O'Connor spawns a multi-billion-dollar disparity study industry in every city in America, and every community college and every state and every whatever will pay for a disparity study, millions and millions of dollars. And lo and behold, what do these disparity studies demonstrate? To a T, they all show that there's discrimination going on in the industry and therefore preferences are required, sometimes heavy preferences, and these preferences have gone on for 30 years. So the challenge to these contracting policies has to come, and it has to go before the Supreme Court soon. We have challenges to not just corporate boards, but to government boards. There are government boards out there. We had a challenge to a government board in Arkansas, the civil service board in Arkansas, that required that 2 people on the Arkansas Civil Service Board be Black. So we had a foster parent who had been doing this work for 30 years, who was not Black, who challenged that. Once we challenged it, the government backed down because it was obviously unconstitutional. They repealed the law. But these types of race and sex requirements on government boards are all over the country. PLF will be coming out with a report soon, hopefully, that will sort of scratch the surface on the extent of these government boards that use race and sex. But it's another area that undeniably needs litigation. In addition to the explicit race and sex preferences, I think there's a strong push to try to police individuals' thought. Now, I think that comes across in the in our CME challenge to California implicit bias requirements for doctors, but it also comes across in another case that we filed challenging DEI statements at universities. Now, my colleague Wilson back there, you want to say, Wilson has filed a lawsuit on behalf of a professor who is challenging the DEI statement at UC Santa Cruz. Now, DEI statements essentially say if you want to be a professor here, you have to pledge fealty to DEI. It's not just that you have to say, you know, DEI is all right, or DEI is, I believe in equality under the law. No. UC Santa Cruz gives an explicit instruction of how you ought to answer if you want to be eligible for a job. And this is the first cut requirement. So it's not like scholarship, where did you go to college? Where did you do your thesis? What are you going to bring? The first cut is whether you score high enough on the DEI statement. And you have to answer the DEI statement how they tell you to answer it in order to make that first cut. So we are bringing a challenge to that. It's just demonstrative of how these education institutions are trying to police how people think and how they ought to react to DEI across the country. Of course, DEI budgets and industries throughout the university system are overblown, and this is just a furtherance of the attempt to police thoughts in that way. I want to end before I open it up for questions with what I see as sort of the corollary to the promise of SFFA. SFFA promises that when we mean to end discrimination, we mean to end all of it. And I think that is one of the many pithy statements of the Chief Justice over the years, one of my favorites. But I want to add to that, when we defend and when we protect the 14th Amendment, we protect all of it. Now, the 14th Amendment, we're here today, I grant, to talk about equal protection and treating everybody equally under the law. But I'm the director of Pacific Legal Foundation's Equality and Opportunity Program. Now, the opportunity side of that means that we want to allow people to thrive, to earn a living, to remove barriers that prevent them from realizing their best self. And the 14th Amendment promises that. There's the privileges and immunities, privileges or immunities clause, which is seen short shrift by the court, was obviously wrongly decided in the Slaughterhouse case in the 70s. There is the due process of law clause. There is the citizenship clause. So when we protect the 14th Amendment, we should protect all of it, just like when we end discrimination, we should end all of it. So as PLF goes forward, we are going to be defending all of the 14th Amendment, and we will be with you there to end discrimination. And I welcome all of you to join me as foot soldiers. We have 3 or 4 in the back that I work with, that if any of the things that I've talked about you experience, then you're a plaintiff, or you know a plaintiff, or you can have somebody to step up and join us and fight this. That is the hardest part of my job. Probably the hardest part of, Ed created an organization that is designed to find plaintiffs because it's hard. We need people to step up and say, what the government is doing to me is wrong, and I will fight. We don't charge fees, it's all pro bono, but we need people to be able to stand up for their rights. So I welcome you. I ask you to join me as foot soldiers in our fight for equality before the law. Thank you.
I'd like to ask you about K through 12 and where some of the thought control permeates the curriculum. Obviously, people have been oppressed. That's not a problem. The question is when it becomes stereotyped and acts as a bias against others in such curriculum like the 4 I's of oppression, and it really marginalizes individuals. Now, in California, we do have in the Ed Code about a section against bias of one group towards another. And yet this curriculum does in fact do that. So can there be a lawsuit that actually reaches into that kind of divisive curriculum?
I think the devil will be in the details in something like that. We've looked at curricula, and we have thought about different challenges to be brought, what that would look like, presumably some sort of First Amendment argument. But at the same time, school districts have wide discretion of creating their curricula. That is normally a good thing. It can cross into violations of equal protection, say with the privileged walks that we see. You don't really see those anymore because they were challenged. And it can, if you're segregating individuals into different assemblies, we've seen stuff like that we've brought. But just challenging curriculum, like the math curriculum in California that says 2 + 2 is 5, that's a lot harder. And I'm open to creative ideas, but it's a difficult legal challenge. And those fights, some fights have to be won politically and have to be won at the ballot box, and that may be one of them.
To paraphrase Gandhi, every system of racial oppression depends upon, on some level, on the consent of the oppressed. I'm personally famous for having posed as an African-American to gain admission to medical school at St. Louis University in Missouri. How would you feel about a campaign revolving around students deliberately misidentifying their race in their applications to college, graduate school, or anything in order to undermine the system, and also in many ways inspired by the Freedom Riders to undermine the system? What would be the legal consequences to students if they did that? Could they prove that a student is not Black? Because what would be the legal consequences for such a campaign of nonviolent resistance to racial oppression?
Well, famously in the Fisher oral argument, they asked, I forget which justice asked the attorney for the University of Texas, how do you know if such and such is Black? Well, they originally said in their briefing, I think, we go around, we count them in classrooms just by looking at them. But they abandoned that at oral argument. They said, well, it's self-identification. That's the only way. So presumably, if you self-identify as Black, then that is good enough for the University of Texas. I am not, as a lawyer, going to tell you to do anything illegal or break the law. But you believe it, it's true.
Thank you, Ms. Thompson. I know we have a lot of questions to answer, but it's almost noon, and I believe many also are starving to have lunch right now. So the lunch, I think, is ready over there. And okay, yeah, go ahead.
I promised that I was going to read a snippet from the email that I sent to PLF, all PLF, after the SFFA decision. I won't read the whole thing because I'll probably tear up, but I did write, today's opinion is a call to action. If our foot was on the gas pedal before this decision, it ought to be on the throat now. The end of government discrimination is within our reach. That's the message that I want to leave you with.